I'm Jacob Stein, and welcome to this presentation on COVID-19 and the planning we can do for the coming COVID-19 recession. These few weeks have been very interesting for both us and our clients, and certainly very challenging. Our thoughts go out to everyone who's been affected by this virus, both personally, health-wise, and financially. These are very tough times, and what we have done is put together a panel of really expert and experienced and knowledgeable speakers who will help us figure out a way through the COVID-19 landscape and how we can minimize the damage that it can do to us and to our clients financially. I will just share my own personal experience practicing here in Los Angeles. So when the crisis started, we first started seeing clients who are in the retail space reaching out to us. So these were operators of restaurants, operators of hotels and other hospitality properties, and just retailers operating retail stores. And they were reaching out to us because they were losing sales dramatically. Some of them were closed by the government, and they were very concerned that they have little or no revenue coming in. They have to let go or furlough their workforce, and they will not be able to meet their obligations on loan payments, on lease payments, and many of these retail operators signed personal guarantees both on leases and on their loans. And they were very concerned about those leases and loans getting called. A week later, we started getting phone calls from operators and owners of commercial real estate. Investors calling, for example, shopping centers across the country. And their phone calls sounded like, hey, our tenants are either leaving or they are not paying us rent anymore. We are breaching our loan covenants, or we do not have the cash flow to make loan payments, and we are afraid we will have to go into default on our loans, and we have signed personal guarantees with our lenders. And then a week after that, we started getting phone calls from mortgage lenders and commercial lenders saying that now we are going out of our covenants. We are going to get cash calls from our guarantors and lenders, and we have signed personal guarantees. So you can see how very quickly, just in the span of 2 or so weeks, this has escalated up the economic chain. And this is sort of just a direct vertical economic chain. Think about all the vendors who service every layer of these industries, right? From the vendors who service physical real estate, to the vendors who service these different retail businesses, to the vendors who service the lenders, right? So the economic impact of this virus, we have seen it firsthand, we have felt it firsthand, and it's just been devastating to so many of our clients and lots of other people out there, and our heart goes out to them. So we would like to help both our clients and your clients figure out a better way to deal with this crisis. So my own practice focuses on asset protection planning, and we right now have just a huge demand for our services. We have helped our clients through the 2008 recession and the personal guarantee calls and other lawsuits they were facing in the light of that recession. So we know how to deal with these recession-driven claims that our clients may have and lawsuits. And we are happy to speak to your clients if any of them want to look for ways to protect their business assets and their personal assets. And we will be recording a separate full-hour presentation on how to protect assets in a driven economy. But this presentation is not about asset protection. We have some amazing speakers for you in this presentation covering corporate law, covering real property law, employment law, and bankruptcy. These are the areas most impacted, areas of the law most impacted by COVID-19 and the recession that will follow or has followed. So I would like now to hand it off to our speakers, and please allow me to introduce our speakers. Our first speaker today is Joel Weinstein. I've known Joel for about 20 years. Joel is a corporate partner at Greenberg Glasgow and he chairs the firm's restaurant, food, and beverage industry group. Joel has extensive experience in corporate, transactional, and M&A type of a practice. He guides his clients through a lot of asset and stock sales, private and public debt and equity financings, lease and distribution agreements, strategic alliances, SEC reporting requirements. Joel is a very experienced corporate lawyer who has seen his clients through at least a couple of recessions, I would think, and he has a lot of depth of knowledge, wisdom, and expertise that he will share with us. Joel, please take it away.
Thank you for attending this webinar that will address the serious impacts of COVID-19. I am Joel Weinstein. I'm a partner at Greenberg Glusker. We are a large general business, litigation, law firm with practice areas covering the needs of national, regional, and local businesses. The disclaimer that you heard at the beginning of this webinar applies to this presentation. I serve as co-chair of our firm's restaurant, food, and beverage group. COVID-19 has had a drastic impact on restaurants, food, and beverage companies. According to the National Restaurant Association, 15.6 million people work across 1 million restaurants in the United States. At least they did until the outbreak of the COVID-19. 78% of the nation's restaurants are independently owned and operated. The industry was on track to exceed $900 billion in annual sales. Now sales are expected to decline by 25%, and I personally think that that number is understated. The biggest single liability, or one of the biggest single liabilities for a restaurant is its rent. You can expect, and we have seen, tenants already approaching their landlords to seek abatement of rent. I'll go quickly through some of the legal theories that may apply to abatement of rent. All of this, of course, precipitated by the fact that in many jurisdictions, restaurants have had to close or limit their sales to deliveries or takeout. So the first one that you may have heard about, the legal theory, is a contractual provision called force majeure. It's a French term. Essentially, if it applies, depending on the details of the contract, it may permit an abatement of the rent during the duration to which the force majeure event remains. Other similar legal theories are impossibility of performance, frustration of purpose. Each of them would, if applicable, would excuse payment for the duration of the COVID-19 type of shutdown or a portion thereof. I expect that you're going to hear more about these theories relating to landlord-tenant relationships later in the webinar. Effectively, what tenants must do is to reach out to their landlords, try to negotiate a solution that's safer than in litigation, find ways to mitigate their damage, preserve evidence of what attempts they've made to support an amendment or modification to the lease, and endeavor to be reasonable. Ask yourself, how will a jury react to your position that you're taking with the landlord? Because jurors will also have suffered. Other lease provisions should be examined to determine whether they might permit a tenant to abate rent, at least for a period of time. What are these provisions? Casualty clauses. The insurance provisions. They may require business interruption insurance, and the question will be whether that business interruption insurance has been triggered. In addition, the condemnation or eminent domain provisions should be examined. I know that you would expect it both as to casualty and condemnation, that there's a physical taking going on, but with the government orders, certainly one could analogize that to a physical taking. So again, the importance is to read the details of the lease. The political landscape may be helpful to tenants. Cities and counties have enacted emergency orders setting moratoriums on evictions and payment obligations. More details I expect will be provided later in the webinar. A topic that's commonly linked to payment obligations under a lease or a loan are personal guarantees. Personal guarantees are in the spotlight. States such as California have statutory defenses protecting guarantors. They're also referred to as suretyship defenses. One of those provides that the guarantor is not liable for the debt of the principal obligor, in this case with the tenant or the borrower, if the principal ceases to be liable on the contract. So some of those theories that I just mentioned that might be applicable to abating rent in the landlord-tenant situation, in a lease, may be applicable and helpful with respect to guarantees granted by the owner of the tenant to the landlord or to a bank, for example. Often, of course, you would expect that the guarantees will contain waivers of those typical suretyship defenses. So until a final decision in favor of a guarantee by a court relating to the COVID-19 situation, guarantors should expect enforcement of the waiver, leading to, again, the absolute need to communicate with the beneficiaries of those guarantees and to try to negotiate some consensual solution to enforcement of the guarantees while the underlying tenant or borrower is working out the financial arrangements. I next want to discuss the health of the business by focusing on 4 constituent groups and good business practices. First constituent group is the employees. There are several federal and state laws that are helpful to employees at this time and are being utilized. The Emergency Paid Sick Leave Act, the Emergency Family and Medical Leave Expansion Act, the School Leave Program, triggered because of COVID-19. It's helpful for employers to be compassionate and empathetic with their employees. They may be helpful by facilitating transition for unemployment benefits, directly assist employees who are struggling mightily in these times. Safety for the staff must be a high priority at any restaurant. Schedule staffing density to levels that allow a minimum of 6 feet distance between employees at all times. Don't create incentives to working while ill or going out while symptomatic. Hold meetings remotely whenever possible. Zoom is very good for that. FaceTime. Create systems for contact-free exchanges of necessary documents, food, and equipment. Maybe prop open any doors that are regularly accessed, and reiterate the importance of hygiene and food safety protocols to all members of staff. Ensure that hand washing stations are well maintained and provide sanitizing stations to non-kitchen workers. Now, with respect to customers, the safety of the customers in the community is very important. How can this be done? Several steps. Transition to takeout service. Well, that's being mandated by several of the emergency orders. Remove all physical menus and payment points to the extent possible. Switch to no contact payment methods. Try to go to online only. Offer contact-free door opening if possible. Offer contact-free pickup. Place ready-to-go orders on a table, say by the front door, with the name of the customer who's ordered it. Use signage to remind guests and customers to maintain 6 feet distance. Remove all condiment bottles, loose napkins, silverware, water bottles, and table decorations. Anything that might result in more than one customer touching the same surface. What happens if the business owner learns that an employee or a customer has contracted the virus. First, certainly inform the building, whoever the owner of the building is. Take steps to notify others who may have been exposed. Consult with the CDC and local health authorities. With respect to customers, the importance remains to sustain the relationship, and one of the ways is by seeking alternative revenue streams. Sell gift cards with premiums. If the restaurant has an alcohol license, use the alcohol license to sell alcoholic beverages with food items. Many cities and counties have liberalized the restriction on consuming or selling and consuming alcoholic beverages outside of the premises. Try to think about selling products like merchandise or sell produce or fruit. Certainly beats waiting in line at the local markets. Several restaurants that we represent have converted to selling more of their produce and fruit, as well as merchandise items that they think would be of interest to their customers. The idea is coming up with creative alternative revenue solutions. With respect to vendors, one of the issues will be whether the vendor can actually perform. And there is the doctrine of impossibility that applies under both many states' commercial code laws, that in the case of some unexpected, unforeseen event that makes it impossible to deliver goods, then the deliverer is excused, at least for the period of time or duration during which that impossibility exists. Again, local laws, state laws need to be examined with respect to the relationships between vendors, suppliers, and any restaurant owners. With respect to lenders, I spoke briefly about the guarantees. The fundamental basis of borrowing relationship needs to be discussed, and discussed as promptly as possible with the lender to try to establish a mutually satisfactory arrangement for payment. Because certainly cash flow and net working capital is going to be depleted and not meet the expectations, which means that the lenders' financial covenants of the restaurants are likely to be breached, and those will have to result in discussions with the lenders to seek some type of a mutually satisfactory modification of those financial covenants during the period of time to which the COVID-19 pandemic is expected to remain. And that's certainly challenging to know at this point in time, so that there may be some short-term solutions and medium-term solutions in dealing with lenders. Lastly, but not least importance, is that constituent group of the owners. Certainly monitor government aid packages. One of the things that was put into place fairly early on in the COVID pandemic has been the pushing back by states of payment of taxes. Seek small business or emergency loan and look at opportunities for that. The new federal stimulus bill, of which you're going to hear more about later in the webinar, will expand unemployment insurance, create the opportunity for emergency loan to small businesses so long as they're not laying off employees and continuing to pay them. And they'll provide relief for small businesses with SBA loans. Don't forget to explore the tax credits that are available to businesses that are paying emergency paid sick leave and family and medical leave. Now, there are several steps to take for any business including restaurants, food and beverage companies who are considering a sale or a liquidity event. What are those steps? Keep good records of how your vendors perform and what you did to diversify your supply chain. Track the changes in inventory levels, comparing what you've carried historically versus that which is occurring now due to the COVID outbreak. Monitor your accounts receivables. Document changes you made in credit terms. Work with your accountant to identify one-time extraordinary or non-recurring expenses that you may be able to add back to earnings. These are now known as the COVID-19 EBITDA adjustments. Keep current lists of your material contracts with force majeure clause. Identify any regulatory changes that have impacted the business. Of course, update your crisis management or disaster plan. Identify changes to your insurance policies, such as your business interruption policy, and document any changes to your employment practices that are coming out of the COVID-19 pandemic. Now, business interruption insurance may be a source of revenue. It's not going to be immediate, and I'm sure it's going to be one that's challenged by the insurers. Again, the key is the details of the insurance policies. These are through their property insurance policies. Oftentimes, coverages are covered with direct physical loss, which may or may not be defined in the standard policy. Specialized policies sold to businesses in hospitalities may provide broader coverage. Business owners have been advised to be proactive and to ask coverage counsel to review the applicable policies. In closing, for more information about best practices and solving business issues caused by COVID-19, visit our Coronavirus Resource Center. That center can be found at our website at www.greenbergglusker.com. I welcome your questions. I can be reached at jweinstein@ggfirm.com. Thank you. Stay healthy and safe.
Thank you, Joel, for your presentation and your remarks. It's very helpful for me and hopefully for everyone who is listening. Please allow me to introduce our next speaker. Our next speaker is Marc Cher. I've known Marc for many, many years. Marc is an AV-rated real estate attorney, litigator, and he's a shareholder of the law firm of DeCastro West. Marc focuses on counseling commercial and residential property owners in the context of real estate and business transactions. He has a lot of experience in structuring purchase and sale of commercial real estate, arranging leases on both landlord and tenant side, real estate financing arrangements, restructuring debts, and representing creditors in all aspects of real property transactions. So Marc, please take it away and let us know how COVID-19 has impacted real property law and your client representations.
Hello, I'm Marc Cher. I'm a real estate attorney in Los Angeles, a shareholder at the firm DeCastro West, and my practice focuses on real estate law, deals, and litigation. I'm here today to offer some practical guidance regarding the COVID-19 and the effect on real estate. A lot of people will be coming to this from different perspectives based on their work in real estate. The pandemic affects owners, affects tenants, affects lenders, property managers, and brokers. And I'm getting calls and doing work with people who fit into all those groups. There's a shopping center owner who has retail tenants, some of which have just closed up, others of which have requested rent reductions, and other tenants who have not said anything. There have an office tenant who would like at least a reduction in rent. There is a purchaser and an escrow for multifamily residential. Now, if you think the rents are worth, let's say, $1, when you enter into the lease and now they're worth 50 cents, that buyer would like to get out of the deal. What do we say to all these people? Does COVID and the effect on the economy caused by the disease itself and the restrictions on going to work and doing business like we were doing just before St. Patrick's Day, are these grounds to pay less to your landlord, to stop making mortgage payments to the lender, and so on? These are difficult questions in a dynamic field, and a lot will be worked out by discussions. And so one area of guidance I can offer is how to frame those discussions with the person who's either asking you for relief or whom you're asking for relief. And then I can also explain the general legal framework. The general legal framework falls into three main legal ideas: force majeure, frustration of purpose, and impracticability. And they overlap a lot. Basically, force majeure, a French term from civil law, basically means that a contract's impossible to perform. And what's going to be frustrating to a lot of people is that contracts are generally not impossible to perform now. Some are, of course. But many, it's just that they'll be expensive or there's no economic purpose to fulfilling the contract. So for example, if you've entered into a lease but not yet moved in, and the landlord or the tenant has agreed that tenant improvements will be completed before rent commences, and you can't get that work done because you can't get some of the items you need, or you can't get the contractors to come to work, or the building's closed down, something like that. That would be a good example of force majeure, and I think that probably could result at least in a postponement of when rent commences. But if you're just saying economically, my business is down, I don't need the space, I don't need the retail space, I don't need all this office space, that's probably not going to fit under that category. Or even, it may not fit under, at least in the real estate context, for frustration of purpose or impracticability, because they're so close. It doesn't, in other words, you still could go to the office. It's not the landlord's problem that you don't have clients necessarily. So what, besides looking at the law, you want to look at your actual documents. In residential, there's generally never a force majeure clause. In commercial leases, there may be, but it may be very limited, and the court's not going to expand it beyond what's in there. So if the force majeure clause just relates to rent commencement, right, related to the build out, but doesn't ever talk about it affecting rent otherwise, then the court's not going to apply it. So definitely everyone wants to look at their agreements to see if there is a force majeure clause or impracticability, and see how it affects whatever the problem is. Maybe it affects the move out date. You're at the end of the lease, but you can't move out or don't want to move out. How much holdover rent do you have to pay? Maybe it's like that person, like I said, who is in contract to buy an apartment building and no longer wants to conclude the deal. So the Federal Housing Finance Agency announced that Fannie Mae and Freddie Mac will offer multifamily property owners mortgage forbearance, but only on the condition that they suspend all evictions for renters unable to pay rent due to the impact of coronavirus. Now, the federal agencies aren't promising that they will grant the owner forbearance if they agree not to evict the tenants, but it is a condition to even considering forbearance. And even then, like all lenders, the agency is going to require the borrower to provide evidence showing that their ability to pay has been substantially impaired because of the virus, causing hardship to the tenants who don't pay. And really, the agency's rule goes in accordance with what we're seeing many cities and states not allowing residential evictions at this time. Also, sticking with residential, the states that have shelter-in-place orders, the transactions for single-family residences have basically stopped because, you can't have any showings any longer. And so what I'm seeing now are, for sellers who really want to go forward, disclosures from their brokers that the seller must sign, warning them of the health risks, and the buyer having to agree that they elected to proceed with the showing, inspection, or appraisal, and will hold their broker harmless if they go ahead with those things, and recommending things like that the owner stay in the yard and leave all the doors open, and require that anyone who visits wear gloves, and all these sorts of things. So it's pretty much killed the home sale market in states like California. And even though the brokers would like to do things electronically, it's still not really, people generally want to see a home to purchase it. So the California Association of Realtors, and this is probably happening nationwide with NAR as well, is working on a coronavirus addendum amendment to purchase contracts, where the parties can agree that if the close of escrow is prevented by reason of the virus, that different options, like the parties can mutually cancel the agreement and buyer's deposit would be refunded, or escrow would be extended by up to 30 days and thereafter it could be canceled, or that if the buyer suffers a loss of income, the buyer can cancel and recover the buyer's deposit. And this is necessary because residential typically does not have a force majeure clause, and that makes sense because it's not income producing. A house is very personal, so really the only income that is relevant is the buyer's income, and so it does make sense to add a clause that says that the buyer's income is adversely affected, or you can't close because the escrow company's closed, the contract could be canceled. For the tenants, if you're a tenant and want to get out, I suggest starting, with a nice letter to the landlord if you want a rent abatement. And, saying something like, we've appreciated and enjoyed partnering with you and hope that you can appreciate we've been a good tenant with a great pay history. But due to the effects, we have to have an open discussion regarding mitigating actions such as rent reductions and deferrals to ensure our long-term viability in our relationship once this crisis is over. And then perhaps outright proposing something like a rent deferral for 2 or 3 months, and that being followed by a reduction in rent through the rest of the year. And stating that, we can prepare a short addendum along these lines. Similarly, if you represent the owner of commercial rental real estate like office or retail, you may want to prepare a notice to all your tenants preemptively, something like, the landlord encourages you to research available financial assistance during the current pandemic. We're optimistic the economy will recover quickly once the panic, well, panic is too strong, once the pandemic has subsided. And then even offering the link to the SBA assistance program at disasterloan.sba.gov, which has to keep being modified so that, because as Congress decides exactly how the program will work. If you get to the next step and you have a tenant that's actually requested rent, then you want to send them a nice letter too that says something like, you're receiving this letter because you have made a request for our consideration. And we, the property manager or the property owner, is sincerely concerned for your prosperity and continued presence at our center, our building, and we want to take full consideration of your request. While we make no promise that your request would be granted, we certainly will make every effort to reach a decision analyzing your particular situation. And then you request things like current financials, like 2019 and 2020 financials, sales reports, payroll. You basically want an open financial book from your tenant. You're not going to be as happy If the tenant is taking out a bunch of profits for the owners and then not paying the rent, you're going to want to see that it's really a loss of sales, and you want a business model. And then it's also reasonable, again, to remind them that the tenant should seek an SBA loan, and also point out that any reduction may not be open-ended. If you do get to the point that you reach an agreement with the tenant, then you're going to prepare an amendment to the lease. And, if you can prepare the amendment and you want it to be pro-landlord, would you prefer to give up the rent entirely, or would you prefer just to defer it? So of course the landlord's going to ask to defer it. But if let's say you defer April and May rent, 2 months of rent, and then you say, okay, I'll defer it, and then you'll repay it to me over the last 6 months of the year, July through December. So you're paying rent in a third for those last 6 months. Well, that's good from the landlord's point of view, but you have to think about where's the money coming from. For residential tenants, they say usually the tenant doesn't have more than a month's savings available to tide the tenant over in a rainy day. And what we're seeing is that businesses, even large businesses, have spent all their money on all sorts of things and don't really have a lot of cash to weather the storm. So you can get a distressed tenant perhaps to agree to pay rent in a third to be relieved from May and June rent. But if you do that, you have to think about how will they suddenly be so great in July? You have to hope that the government puts enough money into the system and the disease plateaus that this comes true. Otherwise, they'll be coming back to you. So, but if you can do it, you would do it sort of an agreement that says, for instance, that the monthly installments of minimum rent for April and May are reduced from, let's say, $9,000 to $0, resulting in total reduced amount of rent of $18,000, which would be the deferred minimum rent. And then you would say effective July 1 and the first of each month thereafter through December 2020, defendant shall remit, so 1/6 of that, $3,000 as the monthly deferred minimum rent payment, and that monthly payment would be in addition to all other amounts paid by the tenant under the lease. And then you'd also have an obligation that the tenant apply for federal aid, and if they get any such aid or state aid, that the first dollars be returned to the landlord. And you can say that with something like tenant shall use best efforts or reasonable efforts to obtain financial assistance from government due to the impact of COVID-19. And to the extent the tenant receives financial assistance, tenant shall pay to the landlord from the first dollars received, if you can get it, the amount received by tenant up to the amount of the deferred minimum rent. That's pretty good. And then along with that, you're going to want a non-disclosure agreement so that the tenant doesn't go boasting to your other tenants that you're a softie and are giving up rent, and pretty soon you have no rent and you're in violation of your loan covenants about rental income. So you're going to do a non-disclosure agreement, and you'll just want it to be the responsibility of the tenant to limit the disclosure of the confidential information. And the tenants generally will go along with that because they'll understand why. Similarly, if the landlord is facing a loss of income, then the landlord can go to landlord's lender and request a forbearance on mortgage payments. And although some foreclosures, mostly residential, are being limited by law, commercial foreclosures, to my knowledge, are not. But informally, the government on every level is leaning on the lenders to make deals with their borrowers, including commercial borrowers, because they don't want a wave of foreclosures. So the lenders don't quite know what to do either, because how long will this go on? But the thing that you will see from the lenders and what I've seen so far is a request, again, for an open book. They want 2019 financials, 2020 financials, and for loans that are guaranteed, and so many of these are guaranteed, updated personal statements, personal financial statements from the guarantors. And then no promises, but they'll evaluate them. And the fact is that if anybody in this environment doesn't pay rent, whether residential or commercial, or doesn't pay a mortgage payment, there's not going to be an immediate legal action. The courts in many states are basically closed. The government has made it clear that if you're a bank and you want $1 billion, or of course they really want tens or hundreds of billions of dollars from the government, that they better go easy on the borrowers, because nobody wants a huge domino effect. Nobody really wants the economy to fall, to crash even more than it has. The somewhat good news is that, eventually things will get better. It might be in a period of 3 years, like after the Spanish flu epidemic. It might be sooner than that. Nobody knows. But often, it takes 2 to 3 years for things to recover. But one thing is that real estate rent should be less, probably will fall over the next year. And so if you have an opportunity to delay renegotiating your lease, you may want to wait a bit. The other thing is that, we're all in this together. So if somebody fails or asks for a rent reduction during the COVID time, they're not really going to be overly blamed because everyone did this. I mean, if we look at our president, of course, he had real estate and business bankruptcies. He allegedly did not pay contractors, and he's the president. And so for everyone who wants to be successful in our system, you look to our leader, and you can see that when everything is sinking, no one's going to blame anyone individual. One of the reasons this harm to real estate is so extreme is because values were so lofty early this year. If this pandemic had come along in 2012, 2013, when we were coming out of the Great Recession, it wouldn't have been so devastating economically because values weren't as high. It would have been more of slowing down the recovery. But now values rose in our major cities, Miami, Boston, Chicago, Los Angeles, San Francisco, Seattle, that it's very dramatic. The only thing that had started to fall already were luxury condos. And although everybody knew that we were at a fragile top, nobody knew what would bring it down. And this has brought it down in a big way very quickly. But at the end of the day, things will recover. If we look, the culture doesn't really change, even as a result of generally a disruption like this. And so what we found is that things that supposedly would disrupt things like WeWork, already before this, already before the pandemic, it was already failing. They'd stopped construction, they were laying off people, and probably coronavirus has completely killed it. And turns out people like traditional office. The whole WeWork idea of energy and synergy and people working on top of each other has probably been killed. But people are social. They will want to return to their offices. They will want to go out to restaurants. They will want to go shopping. They will have that energy. And I think that is one of the positives. The other positive is that people who do have cash on the side, they will be able to purchase real estate, and so much of the profit in real estate is made on the buying at a good price. There'll be opportunities to do that. And for estate planning for real estate families, it'll be time to do gifting because, again, the values will be quite low. And it could be worthwhile to set up grantor trusts and things like that, particularly because the estate and gift tax exemption is so high right now. it'll be a positive time for real estate families to make gifts, if assuming they have money at the end of the day. So, in conclusion, just communicate. Everybody wants to stay healthy, and that's the main thing. This is why we're going to such extraordinary efforts to stop the pandemic, is because in wealthy countries, life is very dear to us, and we're going to go to great efforts to preserve life, but that same sort of value and culture will help us carry through at the end. And just, it's very important, if you're going to default, if you have a client who's going to default on anything, to communicate with the other party. And that's the best way for them to come and help you. And if there is going to be litigation down the line, showing the efforts that you made will make the binder of fact much more sympathetic to the tenant or borrower on the loan when they see the series of efforts you made to come to a reasonable resolution of this difficult problem that's affecting us all. So I hope everyone stays healthy. Again, I'm Marc Cher. If you have any questions, I'd be glad to try to answer them.
Marc, thank you so much for your insightful remarks. Well done. We appreciate it. Our next speaker today is Adam Treiger. Adam is a partner at the law firm Stowell, Zelenga, Ruth, Vaughn, and Treiger. He is an employment attorney, and his practice focuses on litigation prevention and day-to-day employment law counseling. Adam is a frequent speaker on employment law, business law, and litigation issues. He's been featured on NPR's Morning Edition, on various streaming internet radio channels. I've also known Adam for many, many years. He is a fantastic employment law counselor. We use him a lot. Adam, please take it from here and let us know what sort of employment law issues our clients should be concerned with right now.
Hello, I'm Adam Treiger. I'm a partner with the law firm of Stowell, Zelenga, Ruth, Vaughn, and Treiger. I practice in the area of employment law and business law. Today I'm going to talk about the high-level picture of current employment law issues regarding the COVID-19 crisis. There are a lot of legal issues, and in my limited time, I'm only going to be able to talk about some of them, and again, only from a high-level view. But I'll do my best to give an overview to try to help as many people as I can. First, let's talk about Governor Gavin Newsom's stay-home order. In California, that means that everyone needs to stay home except for essential activities such as getting food or medicine or gas. However, also employees are allowed to go to work, and employers are allowed to keep work open if they're in what's known as essential businesses. Essential businesses are not exactly the clearest list. However, you can go to the Governor Gavin Newsom's website, and from there you can link to a list of all essential businesses. Mostly it uses the federal government's guidelines on essential industries, but also the governor has included a little more detail on businesses that are essential. There are so many essential businesses on the list, it's impossible for me to go over all of them now. But some of the broad level things to think about are you in the financial industry, or do you support it? Are you in the construction industry, or do you support it? Are you in the communications industry, or do you support it? Are you in the IT industry, or do you support it? And it goes on and on. So make sure you can check that out to see if your business must close or not. If your workers are under a stay-at-home order, that is going to impact your duties and their rights under the brand new federal legislation called Families First Coronavirus Response Act. Basically, it does two things. First, it expands the Family Medical Leave Act which normally only covers employers with 50 employees or more, and calls for unpaid leave for various triggering events, such as having to take care of your own illness, having to take care of someone else's illness, or bonding with a new child, either newly born or adopted. But now that law is expanded to include any employer that has even one employee and requires a paid family medical leave of up to 10 weeks of paid leave for one triggering event. Before I get to that event, let me clarify that the law actually applies to any employer with fewer than 500 employees, but those between 50 and 499 were already subject to the Family Medical Leave Act. For those larger employers, what this does is it does give a new paid leave for a certain triggering event. For those smaller employers, fewer than 50, it requires the leave at all now, and it requires some of it to be paid. So back to the triggering event. The triggering event is that an employee is a parent who is forced to stay home and cannot work because they're staying home. And the reason for their stay home is that they're taking care of a child who is no longer in school or daycare because the school or daycare has been closed due to COVID-19. If that is true, then that worker is entitled to 12 weeks of family medical leave, 10 of which are paid, paid at 2/3 pay, up to a maximum of $10,000 per employee. Now, if there is an employer with fewer than 50 employees, there is an exemption that is available. And that exemption is that those employers don't have to pay that if such expense would, quote, jeopardize the viability of the business as a going concern. Now, if that's true, then the employer does not have to pay that 10 weeks of paid leave. And there is no way for them to apply for that exemption. It's automatic. However, one day, if the employer is ever scrutinized, the employer will need to prove that they meet that exemption and that criteria. The Department of Labor suggests that the employer document the reasons why it believes its viability will be threatened by such a payment. If you have 50 or more employees, you don't have that exemption, and you have to pay that amount, 10 weeks, 2/3 pay. So that's one thing that the law does. The other half of the law provides 2 weeks of paid leave to paid sick leave to any employee who has certain triggering events. Now, one of those triggering events is the same one I just mentioned. That is the paid leave for a parent of a child who's out of school or daycare because of COVID-19. If that's true, then that 2 weeks, the first 2 weeks gets paid by the federal sick leave rather than by the federal family medical leave. The limit of that pay is going to be $200 a day or $2,000 per worker for those 2 weeks if it's a full-time worker. So if you are an employer with 50 employees or greater, the full allotment of paid time off for that particular triggering event is 12 weeks, but 10 weeks of it are family medical leave at the $10,000 maximum number, and 2 weeks of it are paid sick leave at the $2,000 maximum number, $200 a day, $2,000 max. If you have fewer than 50 employees, the same exemption from before applies. If you can show that that payment would threaten the viability of your business as a going concern, you don't have to pay that 2 weeks pay either. However, there are other triggering events which apply for all employers from 1 employee to 499 employees. Those triggering events, I should read them, are: first, the employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. The Department of Labor has issued regulations at 29 CFR Part 826 and has also issued a narrative set of guidance around the new regulations. The Department of Labor has stated that quarantine or isolation orders include a broad range of governmental orders, including orders that advise some or all citizens to shelter in place, stay at home, quarantine, or otherwise restrict their own mobility. Therefore, the California order issued by Governor Gavin Newsom and similar orders throughout the country, which are generally applicable to citizens telling them to stay at home, do qualify as quarantine or isolation orders as contemplated in the FFCRA, at least according to the Department of Labor. However, the Department of Labor says that employees may take paid sick leave under this triggering event only if being subject to one of those orders prevents the employee from working or teleworking as described in the law. The Department of Labor says that the question is whether the employee would be able to work or telework but for the requirement to comply with the quarantine or isolation order. The Department of Labor goes on to give an example saying that if an employee is unable to work because the employer cannot provide work for that employee, then that would be not this triggering event and the employee would not be eligible for the benefits. The example has to do with a coffee shop. So the Department of Labor says, if a coffee shop closes temporarily or indefinitely due to a downturn in business related to COVID-19, it would no longer have any work for its employees. A cashier previously employed at the coffee shop who is subject to a stay-at-home order would not be able to work even if he were not required to stay at home. As such, he may not take the paid leave because his inability to work is not due to his need to comply with the stay-at-home order, but rather is due to the closure of his place of employment. The Department of Labor goes on to say that the analysis holds even if the closure of the coffee shop was substantially caused by a stay-at-home order. If the coffee shop closed due to its customers being required to stay at home, the reason for the cashier being unable to work would be because those customers were subject to the stay-at-home order, not because the cashier himself was subject to the order. Or if the order forced the coffee shop to close because of a downturn in business, the reason for the cashier being unable to work would be because the coffee shop was subject to the order, not because the cashier himself was subject to the order. Therefore, if you take the Department of Labor regulations and guidance as a whole, you will see that very few employees who are subject to stay-at-home orders will be able to use that triggering event as a reason to get benefits under the FFCRA, because most likely the reason for the employee not being able to work is not being subject to the order his or herself, but rather that the employer is experiencing a downturn in business, or their customers can't use them because of the order, or there are other stay-at-home order related reasons that the employer cannot provide work to the employee, which according to the Department of Labor is not a triggering event under the FFCRA. The second one is the employee is advised by a healthcare provider that they must self-quarantine due to concerns related to COVID-19. So that's pretty general. I would say that would apply to people who have perhaps a pre-existing condition, who, if they go to work, their healthcare provider is worried they would have a higher chance of getting very ill if they get the virus. If that triggering event is met, then those workers get the 2 weeks of federal pay. The third is that the employee is experiencing symptoms of COVID-19 and seeking a medical diagnosis. So if the employee reports that they have symptoms, which common symptoms are fever, dry cough, that kind of thing, and that they are seeking a diagnosis but are not yet have their medical appointment or they haven't got their tests back, they are entitled to the sick leave. And then the next one is the employee is caring for an individual who has one of those things, that is, they have to stay home because of symptoms, or they have the virus, or a medical provider says they have to stay home. And finally, if there's other conditions that a federal agency implements or suggests later, that would be covered. For those people, 2 weeks of paid leave is the employer's responsibility. If they're part-time, it's a 6-month look back on an average 2 weeks, and it's up to 80 hours a week. Up to 80 hours total, 40 hours a week. Although if someone is normally scheduled to work 50 hours in a week, they get the first 50 hours in the first week, then 30 hours in the second. It's 80 hours maximum for a full-time worker. All right, there are many other things to talk about on this law, but I feel that I have to move on because my time is short. The next thing I want to talk about then is layoff versus unpaid furlough. So under California law, an unpaid furlough is the same as a layoff for final paycheck purposes. That means that if you decide to keep someone on as an employee but put them on an unpaid leave of absence, which is called an unpaid furlough, on the day you put them on the furlough, you should give them their final paycheck, including all accrued but unused vacation time. You should not wait until the regular payroll date. That's the same as if you lay somebody off, making them no longer your employee. Second, if you put someone on an unpaid furlough, they're still your employee, but for medical benefits purposes, you can put them on COBRA at that time, or you can keep paying the benefits. You should speak with your medical insurance provider or broker about what your particular plan might require. Also, during an unpaid furlough, employees are entitled to apply for unemployment insurance benefits, just like they would in a layoff. So you can keep them on as an employee and they'd still get unemployment insurance benefit eligibility. Finally, if they're on furlough, they're still your employees, so you don't have to rehire them at a certain point. But if you lay them off, you will have to rehire them and go through all the rehire procedures if you want to bring them back. One issue to think about is your medical insurance provider may require another 60-day or some amount of day waiting time period when you rehire people. So you should talk to your healthcare provider or broker about that too when you're thinking about what the costs of layoff versus furlough might be. Another word about unemployment insurance is that employees are eligible for it even if they are still working, but their hours have been cut by a certain amount, a certain material amount. If you're cutting hours and therefore they're losing pay because of that, employees should may also apply for unemployment insurance and get some of it. Last week, the Congress and President passed the CARES Act, which is a $2 trillion bailout of individuals and small business to help through the financial crisis caused by COVID-19. There are two aspects of this very large law I want to discuss here. One of them is the help given to individual people. Under that part of the law, individual people will be getting checks in the approximate amount of $1,200, and that'll happen sometime within the month of April to help people get through this time of crisis. And also, people who are out of work due to COVID-19 will get federal money to supplement the state money that they will get under unemployment insurance benefits. I believe it's $600 more with federal money than they would otherwise have gotten from the state unemployment insurance benefits. These monies will help employees who are suffering under this crisis. CARES Act also has a great financial benefit for employers who are suffering under this crisis. Those who have fewer than 500 employees may apply to the SBA through their own bank for an SBA loan that will cover 4.5 months of their certain expenses, which are payroll expenses, rent and utilities expenses, and interest on other debts. And these employers and businesses will be able to get up to 2.5 times the amount of these expenses for the covered period, which is February 15th, 2020 to June 30th, 2020. Then whatever loan amounts are spent by the loan recipient in the first 8 weeks after loan origination is all subject to be forgiven by the federal government, and the loan forgiveness is tax-free. So this amounts to a substantially very large amount of government grant money that small businesses, employers can use to help them through this crisis. One thing that employers need to know, however, is that the forgiveness can be reduced or even eliminated depending on whether you lay off people during the February 15 to June 30 timeframe, and don't bring them back within 30 days of the date that the law takes effect, which is April 1st. That also counts if you reduce your payroll expense by more than 25% during that time frame and do not reinstate the payroll amount during the first 30 days. So it does matter a lot how you take care of your employees during this time, as one of the main points of the CARE Act grant to small business was to keep people on the payrolls of these small businesses with the help of the federal government. We also should mention the California WARN Act. So the California WARN Act applies if you have 75 or more employees. And if you were going to lay off 50 or more of them at any particular time, which would include temporary layoffs or unpaid furloughs, you need to give California WARN Act notices. Now, it used to be, before this crisis, and will be again, that when you give a California WARN Act notice, it has to be 60 days in advance of the mass layoff. Well, Governor Gavin Newsom has issued an executive order which has delayed or at least put on hold that 60-day requirement. Now you only have to give as much notice as you reasonably can or is reasonably practicable, even no notice if you have to lay people off immediately because of what's happening during this crisis. But you still have to give the required notice letters to all affected employees, as well as to the EDD, to your local workforce development board, and to the head of government of the city and county in which the mass layoff, even temporary layoff, has occurred. These letters are very technical and have to have a lot of technical aspects to them, and the governor's order even adds to the number of aspects that have to be in the notice. So you should certainly seek legal counsel when preparing these notice letters. I also want to mention that the EEOC has provided some guidance about the ADA and how it's being implemented at this time. The ADA would normally prohibit an employer from taking an employee's temperature or asking about symptoms of a sickness. But given this time of crisis, the EEOC says that the ADA does allow employers to take employees' temperature and to inquire into symptoms of this particular virus to make sure that they're not a danger to others when they come to work. Now, if you do ask those questions or take those temperature readings, you have to make sure you keep the data extremely confidential under the ADA as well as under the HIPAA rules. Also, you still have to reasonably accommodate people for their disabilities under the ADA in this time of crisis, but the normal interactive process that is required can be delayed or changed given the crisis that we're in. That's all. I hope that this is helpful to you, and if you have any questions, you can reach out to me. My email address is atreiger@sdrlaw.com. Thanks very much.
Adam, thank you for your remarks. Insightful, compelling, interesting as always, and very educational. We appreciate it. Our next speaker is Dan Weintraub. I've known Dan, like the other speakers, also for a long time. Dan is a bankruptcy lawyer, and he represents debtors and creditors in all chapters of the bankruptcy code. He has handled a large number and variety of personal bankruptcy cases, business bankruptcy cases, bankruptcy reorgs, business litigation disputes for clients. He is probably one of the best known bankruptcy lawyers in Los Angeles. And Dan, please take it away from here and let us know what impact and what planning our clients should be engaging in from a bankruptcy law perspective.
Good morning, everyone. My name is Dan Weintraub, and I am a bankruptcy lawyer in Southern California. I'm the president of Weintraub & Self, a full-service bankruptcy firm in West Los Angeles. First, I want to thank Jacob Stein and his group for putting this together. We're at a very crucial time for businesses in Southern California and indeed around the world. And the more resources that we're able to tie into frankly, the better off we all are and the more comfortable we all are, because largely when we're dealing and facing the unknown, and we don't have collectively an understanding of how to work through the process that we're in, things can be, or at least seem, scarier than they actually are. So thank you, Jacob. So I'm Dan Weintraub. My firm is Weintraub and Self, and we are a group of lawyers in West Los Angeles that specialize in representing individuals and businesses who are in financial crisis. We are currently operating, as many law firms are now, as a virtual firm. I am meeting with existing and new clients every day virtually via the Zoom platform that we're using here. And this is, of course, in an effort to maintain social distancing and keep everyone as safe as possible while still delivering important advice and services. We're in uncharted waters, that's obvious. Many of our clients are in the retail space, restaurateurs, hoteliers. They're all suffering dramatically, as I think all businesses, including essential service businesses, are. Many of my firm's clients have had to lay off all or substantially all of their employees, and we're all waiting anxiously for the government support and help that Washington has been wrangling over for the last several days. Hopefully there will be resources allocated to allow businesses who now have virtually no income to keep their employees on payroll, pay their rent, pay their insurance, so to basically maintain the coherence of their businesses, so that when we get through this current crisis, and we will get through the current crisis, the businesses will be intact and will be able to start up with their most crucial assets, which are, of course, all of our personnel. I think the good news here is that we, of course, will come out of this, and there's going to be a lot of pent-up demand in many sectors. I think real estate is certainly one, which is going to create a lot of opportunity and hopefully a lot of profit for folks and their businesses. The biggest problems that people are obviously facing now is due to a lack of income, their inability to pay rent, their inability to pay personal or commercial mortgages, to pay vendors, and of course to pay wages. There's a little bit of good news here, which is that the courts have generally imposed continuances or moratoriums on litigation, so at least litigation has been slowed. So if you're being sued and your business is being sued, that is now in a somewhat of a forbearance or a freeze. It will certainly resume in the future, but that may not be for several months. So there's a little bit of good news there. We know that there are many areas in the state of California that have imposed commercial eviction moratoriums. These are not forgivenesses in rent, but they are a deferment of rent. But at least there's a little bit of help there. So given that we're, all of us, dealing with issues pertaining to staff, vendors, rent, and mortgages, what are the solutions that are out there for us? Well, traditionally, we're looking at things like forbearance agreements, debt settlement, debt restructure, and then bankruptcies. And I'll speak briefly about each of those. So a forbearance agreement is a negotiated arrangement between a borrower or a renter and the lender or the lessor, by which the obligation is essentially restructured such that an obligation that is in default, past due rent, or past due mortgage, that obligation is going to be deferred. The lender or the lessor will forbear from enforcing their remedies. So this is a negotiated solution. I think it's something that we're going to see quite a bit of, because I don't think lenders are going to want to move forward in enforcing their rights. The outcome of that is a lot of vacant space or a lot of businesses that end up filing for liquidation, and that's not good for a lender, and it's certainly not good for a landlord. Debt settlement is the second item that I mentioned. So debt settlement is typically a cash for discount approach. So we're going to have, I think here, vendors, credit card companies, other unsecured lenders that are owed money. They're going to have customers such as many of the folks that we know and our clients that owe money that can't be paid and would rather receive something than nothing. So a deeply discounted payment or a series of payments over time, and in exchange, a significant amount of the debt is simply waived or forgiven. So that's what I call debt settlement. A related concept, also an out-of-court concept, is a debt restructure. And in a debt restructure, we're typically going to be looking at reducing interest rates, extending term, reducing payments, all in an effort to find a way that the lender is receiving something, but significantly less than they would, and the borrower is incentivized to continue to pay and finds a number that is workable for them with their business. So bankruptcy is going to obviously become a real important tool. It always has been. I've been doing bankruptcy work for 33 years. I've represented countless companies with revenues as low as, in the several $100,000, and then as high as up to $40-50 million. But typical businesses that I'm working with are in the $2 to $10 million space in terms of annual revenue. Big misconception is you don't need to be insolvent to file for a bankruptcy of any kind, although most businesses are. The bankruptcy allows you to stop an eviction, to stay an eviction. It allows you to stay foreclosures. It allows you to take debt and write the debt down to the value of a lender's collateral. So if a bank has made a loan to your business and has a lien on all the assets of the business, the loan in bankruptcy can actually be reduced down to the value of the collateral that the lender has. It's typically accounts receivable, equipment. We're going to have a lot of restaurants, obviously, who have stopped doing business or whose business is down in excess of 90%, because for now, simply, they're all on takeout and delivery orders. So there's going to be a lot of surplus restaurant equipment. Restaurant equipment is going to be, the value is going to be dropped dramatically. So restaurants are going to be particularly good candidates for this form of restructure, where if you have a lender who's made a loan to your business, that debt may be dramatically reduced in a bankruptcy. You also have the right in bankruptcy to get rid of leases, equipment leases, and more importantly, real property leases that are no longer beneficial. I have several restaurateurs and hoteliers who lease locations, and some of which were struggling with profitability before coronavirus, and now are shut down. Well, you're going to have the ability in bankruptcy to actually reject or give back the lease of space or a hotel location which is not profitable, and get rid of the obligation entirely. On February 19th, a new subchapter of the bankruptcy code went into effect. It's called subchapter 5 of chapter 11, and this is actually intended to assist small businesses. It's a way of going through bankruptcy that's much less expensive and much more efficient than traditional Chapter 11, which can be very expensive. So you're going to want to speak with a bankruptcy professional if you're thinking that bankruptcy might be something to inquire about your business. You're going to want to speak with a bankruptcy professional about the advantages and the disadvantages of a sub-Chapter 5 filing. So we're also going to be speaking with many individuals who have personal liability. They're obligated on leases, or they're personal guarantors of loans or leases for their businesses. And for these people, you want to think about asset protection. So speaking with a qualified individual such as Jacob or myself, he and I work together frequently about strategies to try and protect your assets, and or a personal bankruptcy filing, which would enable you to keep assets, although you would have to make some payments likely over time if the assets that you're retaining have equity. And I can explain that if you want to call and discuss this. I can walk through all of these concepts with you. I frankly think that if bankruptcy is an opportunity for you, that this is a good time to file. The reason for that is that creditors, lenders, landlords are going to be completely overwhelmed with other considerations, and they're going to have their own pressures. So some time ago, I took a retailer through a Chapter 11 case that had approximately 40 locations. And we used the downturn in the economy to leverage negotiations with the landlords. Their choice was either to take back the space or dramatically reduce the rent. And this was during the last recession. And I believe we're going to have very, very similar opportunities here, where if you're a retailer and you have multiple locations, or if you only have one location, I believe that your landlord is going to show significant flexibility in negotiations with respect to the rents that they'll demand. And the same is going to be true with respect to credit card obligations, with respect to other loans, because they're facing their own balance sheet issues, and therefore will show much more flexibility. In the last recession, I was negotiating deals with creditors for 5 cents on the dollar and 10 cents on the dollar, because after all, from their perspective, getting something is better than nothing. I do think that there's going to be a lot of opportunity on the other side of this for all businesses. I think we will come out of this as strong as ever, although the recovery will certainly take some time. Bankruptcy, in my view, is always the last option for a business, but it is one of the many tools in my toolbox for helping an individual or a company that's in financial distress. Sometimes it's the right tool in the toolbox, but it's only one of the tools. We've gone through some of the others in this webinar. If you have any questions about your situation, or you're in need of my services, you can email me at dan@wsrlaw.net. That's dan@wsrlaw.net, and the WSR Law is WilliamSamRichardLaw.net. Or you can call me on my cell, and that number is area code 310-963-1494. I look forward to speaking with you and hope that you found this helpful. Thank you very much.
Well, a big thank you to Joel and Mark and Adam and Dan. Thank you for your remarks, very educational. Hi, everyone. This is Jacob Stein again, and I just want to conclude this, what I hope has been a very enlightening presentation for everyone, with a few words about asset protection planning. Asset protection is something I have been practicing for the past 20-some years, and we've done hundreds upon hundreds of asset protection transactions And we have taken our clients through a couple of recessions. So we have seen firsthand what it looks like when businesses and individuals go through a significant recession. And we have seen clients getting calls on personal guarantees, both loan guarantees and lease guarantees. We have seen all sorts of lawsuits from investors against, let's say, hedge fund managers. I mean, we've seen it all. We've represented mortgage companies and lenders, landlords and retail businesses, and everyone else in between in the context of an economic downturn like the one we will be experiencing or already are experiencing now. What we think is very significant from an asset protection standpoint is first to understand that a lot can be done to shield the remaining assets of your business, to shield your personal assets from whatever may happen. Today, everyone is talking about forbearance and waiting and holding, and nothing is going to happen in the immediate future. But eventually, landlords, lenders, and everyone else will come forward and they will look to collect what is owed to them, right? And while today everyone is in this pandemic together, tomorrow people will forget about it, right? Eventually, society will move on, the world will move on, and people will want their money, and they will come after their debtors, some of them with the vengeance. So the time to plan is today, because today we're still planning to a large extent in advance, right? Today we're still planning before there are defaults. And this is the time to take action to protect the assets of your business, to protect your personal property. I will be presenting, and I'll be the sole speaker at an hour-long webinar that's coming up next week on asset protection planning in the light of the current recession that is starting. And we will spend a whole hour talking about how to protect assets in the context of this recession. So please stay tuned to our channels for notes about that upcoming webinar and how you can register. And with that, thank you so much for everyone who has spoken. Thank you for everyone who has listened and asked questions. And we hope that everyone stays well and healthy. And we will look forward to connecting with you guys at our next webinar. This is Jacob Stein, and we're signing off.